All right. Good afternoon, everyone. Can everyone hear me? All right. Well, first of all, happy Constitution Day. Thank you all so much for coming here today. We are very excited about this, and thanks to everybody who is watching the live stream feed of this. I want to first start with housekeeping, which is if you are an attorney looking for CLE credit, there is a sign up in the back of the room, so make sure you put your name on that. On behalf of Attorneys for Civic Education, again, welcome everyone in the room and the folks online. In case you don't know, Attorneys for Civic Education is just a group of volunteer attorneys and non-attorneys. Our mission is to support civics education. Like the presentation today, we always organize an event for Constitution Day. We also support through fundraising and volunteer efforts for civics education programs for high school students, including mock trial. I think we have some mock trial kids in the house. Yeah, woot woot, okay. The YMCA's youth government program, feel free to woot woot if you're part of that. 4-H, yes. 4-H Know Your Government, and then We the People. So we're always happy to have new members and new volunteers. So if you're interested, attorneysforciviceducation.org. So the reason we are here today, again, Constitution Day, I would like to introduce our speakers, and then we'll get the program started. First, we have Josh Hurwitz. He is our United States Attorney for the District of Idaho. He was appointed in 2022. However, he served at the U.S. Attorney's Office before that since 2012. He is a graduate of Stanford University and Harvard Law School, and is also an adjunct professor at the University of Idaho College of Law. Colby Radish. Colby, raise your hand. He's in the back. He will be our moderator. He is a litigation attorney at Smith Malek with a focus on civil litigation, appellate practice, municipal law, and taxation. Colby has, I think, the distinguishing career of having practiced in all three branches of the state government. He is a huge advocate for civics education, also an adjunct at the University of Idaho College of Law. And he will be asking questions today of Professor Vladeck after his substantive presentation, which leads me naturally to introducing Professor Stephen Vladeck. Professor Vladeck is a professor at the Georgetown University Law Center. He is a nationally recognized expert on the federal courts, constitutional law, national security, and military justice. He is the author of the New York Times best-selling book, The Shadow Docket. Highly recommend. It is a finalist for the 2024 ABA Silver Gavel Award for Media and the Arts. He has argued over a dozen cases before the U.S. Supreme Court, the Texas Supreme Court, and various lower federal, civilian, and military courts, and has testified before numerous congressional committees, executive branch agencies, and the Texas legislature. He's also the co-host of the National Security Law podcast, and editor and author of One First, which is a newsletter about the Supreme Court. You may have seen these little blue pieces of paper at the table up front. Elena is holding one up now. That has information on how you can subscribe to that newsletter. I think it's just stevevladeck.com, and then, should be easy to remember, but if not, there's a blue piece of paper up there for you. Professor Vladeck is a 2004 graduate of the Yale Law School, and has served in various clerkships. And I think probably most importantly, he is a fellow New York Mets fan. So, go Mets. We're still hanging on for the wild card. So right now, I will turn the microphone over to Mr. Hurwitz to give some remarks.
Thank you, Judge. So it's great to be with you on Constitution Day, and it's great to see several of my colleagues at the State Bar here. Professor Vladeck, thank you for coming. It's great to have you. And it's great to see all the students, frankly. I wasn't sure what this room would be composed of today, but I'm really excited to see so many young faces. Show of hands, who knows what the U.S. Attorney's Office does if you're a student? All right, show me again, students. Okay, not very many hands. So let me just start by saying we are the federal prosecutors for Idaho. As the judge said, I've been in the office since 2012 and then was appointed to lead the office as U.S. Attorney in 2022. So I want to talk a little bit about, our perspective on the executive branch and Constitution Day. But before I do, I just want to again thank you all for coming. I want to thank the Idaho Attorneys for Civic Education. This is a fantastic event, a fantastic organization, and as I'll talk about, a really important organization that I'm grateful serves you all here in Idaho. I don't know if Wendy Olson is here. She played a role and invited me. She is my former U.S. attorney, so not only the person that invited me here today, but the person that hired me into our office and continues to make great contributions as a lawyer throughout the state. And I'm really grateful to her always for allowing me getting me started in this work. Carrie Schufler, thank you so much for what you do. I think you're the glue that really holds this organization, the State Bar's outreach to students and youth together. It's a lot of work, but it's great to see reflected here today, so many students here, and you deserve a lot of credit for that, so thank you, Carrie. So Constitution Day is at the U.S. Attorney's Office, which is part of the U.S. Department of Justice. It's a big deal for us, right? It's kind of what we do. We try to implement the Constitution. When I joined the office, Wendy, the U.S. Attorney at the time, administered the oath of office to me, and this happens to all federal justice officials, and I swore to support and defend the Constitution. So I want to talk about what that means. It's, doesn't mean we're going to literally huddle around the document, right, and protect it. That's what the National Archives are for. So it's a kind of a nebulous term, but I think it's, when you think about it, one of the most special things about our country. For centuries, humans have pledged loyalty or allegiance to clans or tribes or nations that are defined primarily by geographic boundaries. But in this country, we call ourselves Americans first and foremost because of the Constitution, this document that provides both a democratic form of government and also defines and regulates the relationships that we have as citizens with our government and as citizens and residents with each other. And from that starting point, and of course it's an imperfect history, right, that we strive for to try to implement the Constitution for all Americans. But from that document has emerged a revolutionary way of life. And I think that's part of what sets our country apart. Baseball as well. But we are right to celebrate the Constitution, and I applaud you, especially students, for being here to learn about it and recognize the role that this set of rules in that document has for our society. As I'm sure Professor Vladeck will talk about, though, the Constitution leaves a lot to be interpreted and leaves us with many, many problems that we have addressed and will continue to address as long as our country's around. Executive power is, of course, one of those. And on that score, I'm humbled to have a few first words about this because, as you know, the U.S. Attorney's Office sits within the Department of Justice, which sits within the executive branch. And our role is to uphold the rule of law. We don't make the laws, the courts interpret the laws, but we are charged with upholding the rule of law. What does that mean? Last week, luckily, Attorney General Merrick Garland defined it in a way that I think does it much better than I ever could. So I'm going to quote from his speech, and this was just last week. The Attorney General said, "There is not one rule for friends and another for foes, one rule for the powerful and another for the powerless, one rule for the rich and another for the poor, one rule for Democrats and another for Republicans, or different rules depending on one's race or ethnicity. To the contrary, we, meaning the Department of Justice, have only one rule. We follow the facts and apply the law in a way that respects the Constitution and protects civil liberties. Now, as long as the Department of Justice has existed, and it came into being after the Civil War around 1870, there have been people that question what we do, whether we actually follow the rule and the code that the Attorney General set out. And of course, there are people we know that question this today. And because I'm part of that system that certain people don't trust, I have an uphill battle persuading them that we do enforce the rule of law without fear or favor. It's my job to earn their trust. I think it's the job of all federal law enforcement and all law enforcement to earn the trust of the people. But we can't do that at the DOJ or in law enforcement by ourselves, and we shouldn't do it by ourselves. Now, it's certainly right and proper for people outside of the government, outside of the executive branch, professors, people like yourself, students, to carefully study and critique what the executive branch, what the president, what the Department of Justice do. And I would submit to you that it's all of our jobs to hold our government accountable. That's, again, in the Constitution, I think. And our legitimacy in the executive branch and the strength of our democracy depends on that. But fair criticism depends on good information and an understanding of how the Constitution sets up executive power. And this is why today's event and civic education in general is so important, and why I'm so grateful to have an organization like the Idaho Attorneys for Civic Education. The word education, Professor can correct me, I don't think it actually exists in the text of the Constitution. But it's definitely in there as a concept, because to have a democracy, or to keep one, as Benjamin Franklin famously said, we need a population that's educated and attentive, and ultimately understands the form of government that folks like myself are trying to support and defend. So let me end by, again, thanking you all for coming, thanking the Attorneys for Civic Education for their work, and renewing, I guess I should say, my open invitation to work with you and connect you with the folks in my office. Thank you again for listening to me and having me, and Professor, welcome to Idaho. I'm really excited to hear your thoughts. And I'll pass it back to Judge Lorello.
Thank you so much for those remarks, and I will pass the mic to our guest speaker.
Thank you, Judge. Hi, everybody. Hi. All right, that was your first test. You failed. I want to say first just what a treat it is for me to be here. It's my second time in Idaho, but my first time in Boise, and I really appreciate all of the work that went into today's event from Judge Lorello, from Carrie, from everyone else who was involved. So thank you for that. I also want to say I wish I had known that when I did my slides that the talk was going to be in a room called the Lincoln Auditorium, because when it comes to presidential power, there's no one quite like Abe. So having Abe Lincoln sort of staring at me while I'm talking about presidential power is a little weird, but we'll see how it goes. So here's what I want to do. I want to spend a few minutes talking about the text of the Constitution, because one of the things we're going to see is it doesn't actually answer most of the really hard questions about executive power. And I want to show you how it doesn't answer them before we dive into what those questions are. I want to set up what really is sort of consensus views of presidential and executive power and where most of the fighting is, like what the flashpoints are. Use a couple of specific topics and specific episodes to illustrate what people disagree about and why. And then I want to try to suggest that where we are today with executive power is actually kind of messed up. Messed up not because we have like a succession of terrible presidents. You might think we do. I'm going to try to persuade you that it doesn't matter. Rather, messed up because there's another branch that rhymes with Congress, right, that has done an increasingly poor job of actually checking presidents of both parties. And so for as much as we tend to think of all of our contemporary discourse in terms of my party good, your party bad, right, I hope that one of the things you take away from today's talk is when it comes to executive power, it's actually trickier than that because, among other things, presidents can be from either party, and it can change pretty quickly. So, you know, it's a little more nuanced than that, and hopefully that will provoke some good questions, or at least some questions, or comments in the form of a question. So we'll see how it goes. All right, so starting off, I like to actually start at the end, just so you guys know where we're going. So my hope is to persuade you of two things this afternoon. First is that there's actually nothing inherently problematic about a powerful, robust president. We actually should, for various structural reasons, want a president who has a fair amount of power. And indeed, that's what the drafters of the Constitution specifically intended. And second, the real problem, as I already sort of previewed, is that the presidency has become too unaccountable, right? And some of that's because Congress has stopped checking it. Some of it is because the courts have weakened existing accountability mechanisms. I mean, sort of everyone bears a little responsibility for this. But ironically, the folks who probably bear the least responsibility are the presidents themselves, which is not to say they're all great. No. But rather, when it comes to presidential power, we should not be offended that presidents exercise it, right? That it's actually a different type of conversation. So in other words, right, it's not the presidency that's broken. It's the separation of powers ability to keep bad presidents in check. And I'll leave it to you to decide who the bad presidents are. My vote is for James Buchanan. I think we can all agree, right? James Buchanan, there's no James Buchanan fan club. Meanwhile, one of you is like the 14th great-grandson of James Buchanan and is going to come after me later. Okay, I like to start with a cartoon. This is from The New Yorker. It's executive power. This how judges think about executive power. And if you can't read the quote, I'll just read it for you. Do you ever have one of those days when everything seems unconstitutional? Constitution Day feels like one of those. All right, so let's do some history. This is actually like a scan from the National Archives of the actual Constitution. Article 2 starts at the bottom of this image. We're not going to read it. It's all of this image, and it's a little bit of this image. It's actually not that long. One of the interesting things about the Constitution, Article 2 is pretty short relative to the rest of it. But let's talk about why there's a president. So what do you guys remember about why we revolted? Why did we rebel? What was wrong with England? It had a king, right? King. Is a king like an executive? You know, ish. Like ish, right? One person with too much power, right? We wanted more representative power. We wanted to distribute power. We didn't want one person who had all this authority. Okay. The problem was that the government we chose to replace King George with was something called the Articles of Confederation. And if you'll forgive me for being a little blunt and a little salty, I'm a New Yorker. I believe in salty language. The Articles of Confederation sucked, right? And they sucked principally because they left the federal government powerless to deal with relatively benign crises. I mean, I went to college in Western Massachusetts. There was a rebellion in Western Massachusetts in 1786 that the federal government was powerless to put down because of the overwhelming force of 27 farmers with pitchforks, right? Like, that was part of what was going on when the drafters of the Constitution met in Philadelphia in the summer of 1787. So, like, one of the weird things about the American history story here is that it seems kind of odd that we broke from an all-powerful king and then got a pretty powerful president. But you have to add the first part, that in between we had a just about completely incompetent, right, feeble federal executive under the Confederation Congress. So, okay, Article 2 of the Constitution tries to fix this by saying that the executive power shall be vested in a president of the, you guys are like, I know this part. Yeah, but have you ever actually put this side by side with the vesting clause of Article 1? Right, so Article 1, that's Congress. And just in case you didn't notice it, I put it in yellow highlight. Right, there's a pretty important difference in how Article 1 talks about legislative power and how Article 2 talks about executive power. Article 1 says the legislative powers herein granted, meaning just the stuff that follows in the next, 13 paragraphs, right? That's legislative power. Right off the bat, Article 2 is like, nah, right? Executive power is different. Executive power exists beyond what's just in the text of the Constitution, okay? Right off the bat, that's a pretty big difference. It also tees up our problem, which is whenever we talk about Congress, the constitutional question is what specific textual provision of the Constitution is Congress relying on? If someone says, hey, a statute Congress passed is unconstitutional, usually they can say, because this provision didn't authorize it. It's not commerce, right? Or it's not necessary and proper. Executive power is weirder and harder from the start because not all of it's necessarily spelled out in Article 2, right? Some of it is just implied, or another word might use is inherent. Okay, that's going to shape our conversation. Article 2 also tees up what is really the central debate about executive power by distinguishing between three different kinds of things. First, right, what we might call the president's administrative role. So this is the president as chief bureaucrat, right? The president is the head of the executive branch. He controls his subordinates. The attorney general, the U.S. attorney for the District of Idaho, report to the president, right? That's bureaucratic control. The president's also commander-in-chief of the military, right? That was a really important provision the founders put in to make sure a civilian would be in charge of the military, and not just any civilian, but the one we voted for, right? So these are what we might call superintendent's powers, the powers to basically command through your subordinates. He can also, my favorite, request opinions from the heads of departments. This seems not that important today, but actually back then it was not obvious that the president could hey, Secretary of the Treasury, can I do this? Kind of a big deal. All right. Then there are substantive powers, powers that the Constitution expressly gives the president and the president alone. So pardons are a great example, right? The president has the unilateral textual power to pardon any offense against the United States, any federal crime. That's a big deal, right? The president alone is a check on prosecutions, on convictions, on courts. The president, right, is the one who receives ambassadors. All right, you guys might not get at all fired up about the receive ambassadors clause. Have you ever sort of lost sleep over the receive ambassadors clause? Probably not, okay? Here's why it matters. Where's Jerusalem? Well, really? So that's actually a fight, right? That is a decades-long debate in American government. You guys are like, whoa, this just got serious. Right, so from 1952 until 2017, it was the consistent position of the U.S. government's executive branch that Jerusalem is not in Israel. Why? Because it was just easier that way. Not because that's factually correct, but because to say that Jerusalem is not in any one country was a way of keeping multiple sides happy, right, in the controversial, divisive politics of the Middle East. Congress came along in 2002 and said, to hell with that, and said, no, Jerusalem's in Israel. Duh, we can read a map. And if you are an American citizen whose kid is born in Jerusalem and you want their passport to say Israel, you get to do it. Well, who issues passports? The State Department, right? The executive branch. And so this set up a fight about whether the president or Congress could decide where Jerusalem is. Now, do you guys want to go to law school? I want to be a lawyer so I can fight about legal questions like where is Jerusalem? Believe it or not, this case went to the Supreme Court not once, but twice. And finally, in 2015, the Supreme Court said it's the executive, the president wins because he gets to receive ambassadors, right? The receive ambassadors, you guys were sleeping on the receive ambassadors clause. But actually, it's a powerful, substantive power of the president to decide which foreign countries he's going to recognize, right? To decide where those countries are. And that has lots of ramifications down the road. So again, some textual powers that are expressly the president's alone. Really importantly, and this is actually central to what the U.S. attorney does, the power to take care that the laws are faithfully executed. Faithful to what? The Constitution does not say, right? I think the best argument is faithful to the Constitution, but there's a little bit of room for debate. But that means it's the president's job to decide not just to enforce the laws, but how to enforce the laws. This means two different things, right? Suppose that the Justice Department doesn't actually have the resources to prosecute every federal crime, right? Can the president decide what to prioritize? Can the president say, I'm not going to prosecute marijuana possession? You guys are like, yes, he can say that. I mean, not that I've ever thought about that, seriously, ever. Right, so some of Article 2 is clear about things the president has, powers he has, discretion he has, right? And then we get to sharing power. And then there's the parts of Article 2 that say, and there's stuff the president can do not by himself, but with at least someone else's help. So, for example, the Appointments Clause, which gives the president the power to appoint officers throughout the federal government. The president appoints Supreme Court justices. The president appoints cabinet secretaries. But the Senate has to approve, right? So the Senate in that context is supposed to be a check. The president has some appointment power, right, but not unilateral power. The president could not put Simone Biles on the Supreme Court without the Senate approving it. The Senate could approve it, right? I was debating Simone Biles or Taylor Swift, or Chappell Roan. I don't know. We're, one of the three. Okay. I have an 8-year-old daughter and a 6-year-old daughter, so this is my pop culture experience at the moment, right? My law students are like 22, 23, 24, so I'm 20 years older than them, so my pop culture gap is, I've got them surrounded. I've got the 8-year-olds and the 44-year-olds. All right. All of this stuff is in Article 2. What is not in Article 2 is how do we resolve conflicts, right? How do we decide when the president claims power that's not textually in the Constitution? How do we decide when Congress passes a statute purporting to limit the president's power, right? How do we resolve who wins when there's a separation of powers contest between the legislative branch and the executive, like the Where is Jerusalem example? All right, so let's start with where there's actually a fair amount of agreement, because agreement is good. Like, we are so conditioned in today's political culture to think that everything is a fight. You guys say, no, it's not. Well, we're getting there. Okay. Thank you. You've been a lovely audience. So I actually think it's worth reminding everyone that actually a lot of our constitutional understanding is pretty well settled. We know the president has to be 35, right? There's no fight over whether that's adjusted for contemporary life expectancy, right? So here's some things that are settled. Everyone agrees that the president has at least some powers to act without specific congressional authorization beyond the text of Article 2. Let me give you an example, and we're back to Lincoln. Okay, Abraham Lincoln is sworn into office on March 4th, 1861. I know I was there. No, Congress was not in session. That might surprise you today, but actually Congress, much like the Idaho legislature, used to be a part-time operation, right? Congress was in session maybe 2 months out of the year, 3 months out of the year, well into the late 19th century. And indeed, Congress in the mid-19th century did not usually come to Washington until December, because who wants to be in D.C. in the summer? Right? And so Lincoln's sworn in on March 4th. By March 4th, 7 southern states had seceded, right? And so Lincoln has a problem. He has a secession crisis on his hands, and he has no Congress. The first thing Lincoln does is he calls Congress back into session. But it's 1861. They can't get on planes, right? So he calls them into session for July 4th. Not totally a coincidence, but probably about as soon as you could get people from, like, California, right, to D.C. in 1861. So meanwhile, from March 4th to July 4th, I know math is hard, but that's 4 months, right? Lincoln is the entire federal government. Is he powerless to act? Of course not, right? The Constitution clearly understood that presidents could act at least to some degree without Congress because Congress would not always be there, right? So, for example, the president can defend the United States, right? The president does not need to wait for Congress to repel an invasion. On December 7th, 1941, if FDR had actually, well, some people knew, if FDR had actually sent out the Army and the Navy to stop the Japanese attack on Pearl Harbor, I don't think anyone would say that was unconstitutional, right? Even though Congress had not authorized him to do it. Okay, so again, we start from some power to act alone. The president also has at least some power to interpret acts of Congress, right? When U.S. attorneys enforce criminal statutes, that's the executive branch making a determination that in a particular case, a defendant violated a statute, right? That their conduct fits within what a statute prohibits. That's interpretation, right? When a statute says, hey, I don't know, National Highway Transportation Safety Administration, NHTSA, an agency you've probably never heard of, right? You have the power to pass rules for safety on the highways. And NHTSA says that gives us the power to impose, I don't know, seatbelt laws, right? Or speed limits or weight limits, right? That's interpreting statutes. That's the executive branch saying, here's a statute that we're interpreting. Okay. At least some discretion over how federal laws are to be enforced. We talked about resources before, right? What if Congress doesn't give the executive branch enough money to enact all of these statutes, right? What if the president doesn't have enough personnel, right, to enforce all of these statutes? All right, so that's where we start. We start with consensus. And what you hopefully see already, guys, is this is a lot of power, right? A lot of power to act unilaterally, a lot of power to interpret, a lot of power to decide what we're going to prioritize as an executive branch. So what are the fights? All right, so fight number one, right? Can the president refuse to enforce an act of Congress? What do you think? Yes, no, maybe. So he can veto, right? But suppose the law's already on the books. Can he retroactively veto? No, right? Hey, I wasn't president in 64, but I really don't like that Civil Rights Act, right? No, that's not how this works. Okay, can he refuse to enforce? So usually we think the answer is no, but what if he, the president, thinks the statute's unconstitutional, right? I'm not enforcing it because even though Congress passed it, I don't think this is constitutional. We don't know, right? The Supreme Court has never actually settled that question. So can the executive branch decline to enforce statutes it believes to be unconstitutional? Let me give you a recent example that was super controversial. Many of you are too young to remember this, but about, 15 years ago, President Obama, right, through his Attorney General, then Eric Holder, announced that the Justice Department was not going to enforce the Defense of Marriage Act, right, a federal statute that defined marriage at the federal level as being only between a man and a woman. Why? Because the Obama administration took the position that that statute was unconstitutional. Okay? Was that legit? Well, the Supreme Court eventually agreed, but the president went first, right? So disagreement about when the president can do this, how much he can do this. Can the president defy an act of Congress? All right, so imagine a statute says, hey, presidents cannot, there's a statute that Congress passed in 1971 that says no citizen, right, can be imprisoned or detained without an act of Congress authorizing it. Not a crazy statute, right? If you're going to be put in jail, if you're going to be put in military custody, there should be a statute. Or if the president says it's a wartime emergency and I have to detain this person because they're a threat to national security, never mind that there's no statute, right? That issue was litigated about 20 years ago. The Supreme Court never conclusively resolved it, but that was a fight, right? Can the president say sometimes, if I comply with this statute, it would be unconstitutional? Another thing the Supreme Court has been loath, right, to resolve. How about Congress's power? We talked about the bureaucracy. What about Congress's power over the bureaucracy? So, for example, right, can Congress say, hey, Mr. President, you can pick anyone to be Attorney General as long as they're a Democrat? I think we all say no, right? Because if it's Republican, fine, or the other way around, right? But how about if the Attorney General has to be a lawyer? So there's actually one officer in the entire federal government who by law is required to be a lawyer. You guys know who it is? It's an Idahoan. Solicitor General, right? The Solicitor General of the United States has to be a lawyer. That's it. Right? The U.S. Attorney does not have to be a lawyer. Sorry, Josh. We prefer that they are. Right? So again, right, Congress, this is weird. We think it's odd for Congress to control the bureaucracy, and yet maybe imposing some limits on who can hold jobs is okay. How about removal? Can Congress say you can only fire the U.S. attorney if he or she does something bad, right? Only for a good cause. This is a fight, right? There's a debate about the extent to which the president has to be able to fire all of his subordinates, right? And even if you think that the president should be able to fire all of his close senior subordinates, what about, the sort of the civil service, right? What about the line folks who have no political appointment at all? Again, a big fight. Okay, you guys are getting really excited, I can see. Just the most riveting talk you've ever heard in your lives. And then, and this is getting more to current events, there is a robust, ongoing fight about the extent to which the Constitution gives the president privileges and immunities, right? Special protections from being sued, from being prosecuted, from having to turn over evidence and other information that other people don't generally get to have, right? That's a big part of what the Supreme Court was dealing with last year. So you guys see what's sort of settled and what's not. And what's really, I think, relevant to point out is almost all of the flashpoints of what's not settled, guys, are conflicts, right? Almost all of the flashpoints are areas where there is some head-on divide between something the president is doing or wants to do and something Congress has said to the contrary, right? That's where almost all of the fighting is. Okay, so key takeaway number one. You guys ready? Still debating it. Okay. If you say no, I can do more history. No more history. Well, in 1497, okay. So it has been commonplace that what this is one of the takeaways from what we've been saying. What do you guys know about executive orders? They're bad, right? The executive order is bad. No, right? Executive orders are actually just the manifestation of how the president interprets statutes Congress has passed, right? Constitutional provisions. And so it's been commonplace for politicians to complain about a president of another party using executive orders. This goes both directions. There are Democratic politicians who complained about executive orders from President Trump. There are Republican politicians complaining about executive orders from President Biden. But these are really not per se problematic. The question just is the president's reading of the statute or the Constitution valid? Right? Sometimes they are, sometimes they're not. They're not per se a problem. That's how the executive branch does its interpretation. So, number one, right? Just because the president is interpreting something does not make it wrong. Even if it's a president you don't like. Maybe especially if it's a president you don't like. All right, number two, right? The real question is about constraints. The real question is about Congress's power to mandate that the president enforce the laws, that Congress limit the president's power to control his substantive powers, or that Congress tries to insulate his subordinates. Those are the three really big ones. Okay, so let's talk about this. What this is really about is a debate between, on the one hand, what we might call inherent power. That's the power of the president to act by himself. And on the other hand, what we might call preclusive power. And preclusive power is the power to act in the face of, right, other branches. In the face of other branches saying you can't. Okay? And this is Justice Robert Jackson, one of the probably most important Supreme Court justices when it comes to theorizing about presidential power. In one of the most famous presidential power decisions, the 1952 ruling in the Steele seizure case. Have any of you guys heard of this case? Some of you. Okay. So this was about whether during the Korean War, President Harry Truman could seize steel mills across the United States. There's about to be a nationwide steel strike. Right? Steel workers were striking for higher wages. And Truman said, it's the middle of a war. We can't afford to have interruptions in our steel production. All right? So what he wanted to do was he wanted to take over the steel mills so they'd continue to turn out steel while the strike was going on. Right? And the Supreme Court struck that down. The Supreme Court said, the problem here is not, right, that you seize the steel mills. The problem is that there are statutes that said basically that you can't. Right, that Congress had had opportunities to authorize this and it didn't, that there were a couple of statutes where Congress had almost specifically prohibited it, and that was the key. And Justice Jackson, in his famous concurring opinion, said, imagine what would be true if the president could win in these cases. Right, he says, when the president takes measures incompatible with the expressed or implied will of Congress, his powers at its lowest ebb, for he can then only rely upon his powers minus Congress's. Courts can sustain the president's actions in that case only by disabling Congress from acting. And presidential claim is such a power must be scrutinized with caution, for what's at stake is the equilibrium established by our constitutional system. So we should be really, like, he's not saying there's no such power, right? He's saying we should be wary of it. We should think about it narrowly. All right, so substantive powers. When it comes to domestic authority, right, the Supreme Court, as in the Steele seizure case, has been pretty skeptical that the president can ignore or defy Congress if it's purely a domestic matter. And that's where the Steele seizure case comes in. When it comes to foreign relations, right, the court has been much more on the president's side. I mentioned the Where is Jerusalem case. It's called Zivotofsky, right? That's the most recent example. But there are others going back generations, that the president has more power to act even in the face of Congress when we're talking about foreign affairs, our relations with foreign countries. Why? Because the text of the Constitution of Article 2, right, gives the president clearer authorities in those spaces. Commander-in-Chief, the president's power to control the military. Everyone agrees that this means the president has to be in charge. Believe it or not, in the middle of Reconstruction in 1867, Congress was so mad at Andrew Johnson, speaking of bad presidents, that it passed a statute making somebody else commander-in-chief of the Army, right? Literally. Ulysses S. Grant was made commander-in-chief of the Army. The Supreme Court never got to strike that statute down. It was pretty clearly unconstitutional, right? So he gets to be commander of the military. Does that mean he can use the military to do stuff Congress hasn't authorized, right? And that's where we get to war powers. Much messier. This is where there's still massive debate today. Everyone agrees the president has at least defensive war power, the power to act by himself to protect the country. But where's that line, right? Let me put it to you this way, right? On December 7th, right, could FDR have shot down the Japanese airplanes? So once they entered U.S. airspace, for sure. What about sinking the Japanese aircraft carriers on the morning of December 6th? So, right, I'm a law professor, we do hypotheticals, right? Somewhere I can find a line between where you're going to say, yes, FDR could act, and no, he couldn't. And that line is the debate, right? We all agree, right, the presidents have at least some ability to act unilaterally in defense. The line between offense and defense is fact-specific, right? It's not in the Constitution. All right, so there's another flashpoint. Okay. Instead, guys, what we really fight about today, this is a statute called the AUMF, the Authorization for the Use of Military Force, that Congress passed on September 18th, 2001, 1 week after 9/11. This is still on the books today, right? Congress has not touched this statute in 23 years. And it's worth reading, right? It says, the president's authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines were responsible for 9/11. Okay, so note, Congress has actually given the president a ton of power. So in this space, the fight is actually not over the president's power to act alone, right? The fight is over what the statute means. If the president says, hey, there's a new group in the Middle East that we need to use force against because they're connected to Al-Qaeda, right? Is that in the statute? Guys, that's not a fight about the Constitution. It's a fight about a statute, right? That's where a lot of the flashpoints today are. Let me give you a more sort of home front example. Student loans, right? Something you guys will soon have to grapple with, hopefully, right? There's been a lot of fighting about President Biden's effort to provide forgiveness for student loans, right? In public discourse, those debates are often framed as massive constitutional contests. They're not. They're just fights over whether particular programs are or are not authorized by particular statutes. Right? So one of the things about presidential power is that a lot of it comes not through claims of constitutional authority, but just how a president interprets a statute, like this one. Okay, flashpoint number 2, the president's control over his subordinates. So you might have heard the term the unitary executive before. And if not, you now have. So if I ask you the question now, if you heard the term, you have to say yes because you just heard it. Sneaky, right? I didn't ask. Okay. So what is the unitary executive? The unitary executive is a theory that started out in a bunch of law review articles. Doesn't that sound exciting? Right, in the 1970s and 80s, but has come to prominence in the Supreme Court's jurisprudence. And it's the idea that Article 2, right, makes the president the president, right? From a 2020 case, under our Constitution, the executive power, all of it, and the Supreme Court even put that in like emphasis, all of it, is vested in a president who must take care that the laws are faithfully executed. The argument is that it's all the president's and nobody else's, right? So Congress cannot, under this theory, impose limits on the president's power to appoint. Congress cannot impose limits on the president's power to remove, right? If you take that theory to its extreme, it means you can't have independent agencies, right? It means that the head of the Food and Drug Administration has to report directly to the president and serve at his or her pleasure. It means the head scientist at the Centers for Disease Control, right, has to be directly politically accountable. So there are big stakes to this fight, right? Like, can Congress create positions in the executive branch that are not immediately, directly, politically accountable? There are arguments on both sides, but it's a big deal for the Supreme Court in recent years to lean more and more toward no, right? That the president has to have the power to control the entire executive branch. All right, last point, number 3, I mentioned privileges and immunities, right? So in 1974, Richard Nixon, some of you guys might remember him. Some of you guys might have heard of him, and some of you guys are, we're working on it, right? The Watergate tapes case, President Nixon had a secret recording system in the White House, and his tapes had been subpoenaed as part of a criminal prosecution of 6 of his subordinates. He argued that the tapes could not be disclosed because the Constitution creates a privilege that protects him from disclosure. And the Supreme Court said, well, and the court made a compromise. In a unanimous ruling written by Chief Justice Warren Burger, who Nixon had appointed, the court says, yes, there is something called executive privilege in the Constitution, but it's not absolute. And it can be overcome if there are really, really compelling reasons in a particular case. And guess what? There are here, right? Lo and behold, right, within a week of this decision, Nixon releases something that comes to be known as the smoking gun tape, which is the tape that basically proves that he was aware of the Watergate conspiracy cover-up. And within a week of that, he resigns and is no longer the president, right? So yes, there's a privilege, but it's not absolute, and actually it can be overcome. That was Nixon. 8 years later, same Nixon. Now he's out of office, but the question is, can he be sued for damages for misconduct while he was president? Now the Supreme Court says no, right? That actually would interfere with the president if he were liable for damages for actions that he takes officially while he's president. And the Supreme Court relied heavily on that very argument this July, right, just a couple months ago, when it held that at least for core presidential functions, right, presidents can't even be criminally prosecuted, okay? That's a big deal, right? You might like that ruling, you might hate that ruling, you might never have thought about that ruling before. What it does, right, is it makes it harder to have the pre-existing, the sort of accountability mechanisms, right, work the way that the founders arguably meant them to. And so, right, it means it's going to be harder for us in the future to hold bad presidents accountable, whether, they're Republicans, Democrats, or Klingons. Klingons would be very bad presidents. Not enough of you are Trekkies. All right, we got to work on that. All right, so, what's that? Presidents? I mean, they'd be ruthless. They would get stuff. I was literally just thinking they would get. I wasn't going to say. I had a different word for stuff, but yes, they would get stuff done. All right, guys, where is all this going? Right. So there's a lot more we could say if we were trying to do all of executive power in an hour and a half. We're not. We're trying to just give you sort of an overview of how we got to where we are, and to sort of tie these threads together. Right. The founders created a strong precedent, but also a whole bunch of interlocking checks. Right? If I were to ask you guys to name a bunch of the presidents between, say, Thomas Jefferson and Abraham Lincoln, I mean, some of you are nerds, so you will, right? But some of you might actually struggle to remember luminaries like, William Henry Harrison and Martin Van Buren and my favorite, right, Franklin Pierce. Why? Because presidents actually weren't that powerful. In the mid-19th century. They had these powers, but Congress had not really activated them, right? Congress really did a lot to keep presidents in check. Then you have the Civil War, and that really leads to a robust expansion, not just of executive power, but of federal power. There's all kinds of stuff the federal government starts doing during the Civil War that had never done before because of the war. right? But then we have a whole nother run of like middling presidents. I mean, how many of you guys are Grover Cleveland stans? One of you is like, I want to raise my hand, but I'm scared. Right? It's really, guys, only World War II and the aftermath that sees the rise of the modern presidency, right? Where you have presidents of both parties exercising an awful lot of power, some of which Congress has delegated, some of which it hasn't, right? And that's part of why we get to a more partisan executive branch. Because the more powers presidents are exercising, the more control presidents have over their subordinates, right? The more that they are left to decide these major questions on their own, the more that we are going to see our policy fights in partisan terms, right? We associate policies much more today with presidents than we used to. Used to be we talked about Congress. Let me give you an example. Immigration policy. There's something you guys probably have no feelings about, right? Why is immigration policy such a flashpoint, right? Why every time a new president comes to office is there such a massive pushback on immigration policy? Because the presidents are going it alone, right? Because the last time Congress passed meaningful immigration reform was 1986. Not a coincidence, the last time the Mets won the World Series, right? That leaves presidents to have to be more sort of to own their policies. And it means that the policies themselves become a basis for attacking a president of the other party, right? So instead of talking about like how a president's enforcing a statute, we're talking about whether a particular asylum program is legal or a particular parole program or student loans. Again, because more and more power means more and more partisanization. All right, more depends upon executive orders, right? Without more of these statutes, as Congress is doing less in this space, presidents are left to sort of reach for ever more ambitious interpretations of statutes, right? During COVID, you guys remember COVID? If you say no, I'm going to be really worried, right? So during COVID, okay, a really great example of this, the Centers for Disease Control tried to put out a moratorium on evictions, right? And the theory behind the moratorium was that if you kick a whole bunch of potentially COVID-infected people out into the streets, it's going to actually spread the infections broader. It's going to be a massive public health problem. The statute on which the CDC relied in 2020 and 2021 to announce this policy was enacted in 1944. Right? It's the Public Health Service Act of 1944. We're putting, right, new wine into old bottles. It's a big part of why presidents have become such more flashpoints for their policies, okay? And throughout all of this, less accountability, right? Congress is not just passing fewer statutes to make federal policy. Congress is passing fewer statutes to hold presidents accountable, okay? There was a remarkable uptick after Nixon, after Watergate, in statutes where Congress was actually trying to impose limits on the president. There's a statute called the Ethics in Government Act of 1978. Right? There's the Inspector General statute of 1977. Right? There's the Independent Counsel statute. I mean, there are literally dozens of statutes Congress passes to try to rein in the presidency. We don't do that anymore. Right? I was in the early 2010s during the Obama administration. The House Judiciary Committee, when it was under Republican control, held a series of they created a task force. It was called the Task Force on Executive Branch Overreach. Sounds spicy. I mean, probably today they'd call it the Task Force on like executive tyranny. But, you know, we were getting there. And the goal of the task force was to try to document all of the ways in which President Obama was abusing power. And they kept holding hearings where witnesses from both parties were saying it's your fault. Right? You, Congress, have enabled this overreach because you've stopped doing your job. All right, so this is where we get to the Federalist. How many of you guys have read part of the Federalist before? Okay, you've heard of the Federalist. You've listened to Hamilton the musical. Right? All right, Hamilton wrote the other 51. All right, here's what he didn't write. Literally number 51. Right? So Federalist 51 is by Madison, and it's actually one of the most important discussions of separation of powers in the Constitution. And what Madison said is really important. He said, listen, we're not creating hermetically sealed branches, right? We're creating branches that should be fighting with each other. He says, right, the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the means and the motives to resist encroachments of the others, right? The provision for defense must, in this as in all other cases, be made commensurate to the danger of attack. Ambition must be made to counteract ambition. Okay? We want ambitious presidents. We want ambitious courts, and we want an ambitious Congress, because as they're all fighting with each other, that's how the checks and balances works, right? The problem is not that we have an ambitious president, okay? One of the reasons why we have a president is to be ambitious. We want presidents to be ambitious. My favorite example, the Whiskey Rebellion. Have you heard of the Whiskey Rebellion? Oh, okay, so I'm just keeping track of it. So Whiskey Rebellion, yes. Nixon, maybe. Okay, so the Whiskey Rebellion, in response to a tax revolt in western Pennsylvania, right? President Washington calls out state militias to put down the unrest and to restore order, right? But he did so only by following a bunch of statutes Congress had passed, specifying exactly what the president should do in a crisis, right? It was an ambitious executive relying upon a whole bunch of statutes. That was the original understanding. Okay, fast forward to today. And as I think you've probably figured out by now, my real target is not president, it's Congress. And our contemporary problem has two dimensions. All right, first, we have a Congress that's unambitious. Now, you might say, what the hell are you talking about? Like, those people are on national television all the time. Yeah, I don't mean politically ambitious, right? I mean institutionally ambitious. We have a Congress that is not interested in asserting Congress's power as such, right? The only time you ever really hear members of Congress talking about reining in the executive branch is when the president's from the other party, not when it's the president of their own party, okay? And so what this means is Congress has stopped asserting its primacy in policymaking, or, right, the full extent of its ability to constrain the other branches, the courts and the presidency, and not to let the courts off the hook, because I'm a law professor, right? The Supreme Court, as part of this story, right, has removed comparable checks from the executive branch. It's given the executive branch more control. It's given the president more immunity, partly perhaps because the court itself has been less accountable to Congress. All right, so speaking of the court, there they are. Hello, court. Can you name all 9 of them? Don't, no. We'll do it later. All right. But like, right, the Supreme Court is also part of the story because the court over the last 10 years has not just been giving the president more immunity, but giving the president more control, right, over the executive branch. All right, so this leads to my thesis. The biggest problem facing executive power, and indeed I would say the separation of powers in our entire constitutional system today, is the fecklessness of Congress. You can go look up fecklessness later, right? But like sort of the lack of institutional ambition. Its basic unwillingness to act in its institutional as opposed to its partisan interests. One phrase that I really like, we live in an age of separated parties, not separated powers, right? We will like some presidents more than others. We will complain that presidents we don't like are abusing their powers. Some have, but they're not always, right? But we're only in this position because the presidency has continued to arrogate power with lots of help from the courts, and Congress has acquiesced. And so whether you see abuses of executive powers coming primarily from Democratic presidents or Republicans or Klingons, still waiting for, Gowron, the president, the best way to insulate against comparable abuses, no matter which party you vote for, right, is not about voting for the other party, right? Rather, it's to vote for members of Congress who will work to restore Congress's power regardless of whether the president's on their team, right? To get us back to a place where the separation of powers takes precedence over the separation of parties. Until that happens, we're in for more of the same, right? We're in for more divisiveness that infects so many of our policy debates where it's impossible to distinguish between policies we don't like and policies that we claim are illegal or unconstitutional. We'll continue to fail to distinguish, right, between those kinds of arguments. We'll leave presidents either powerless to respond to policy crises like COVID or needing to rely upon strained interpretations of the relevant statutes like the CDC. And the institution that ends up in power the most is actually not the presidency, but the only one that's left to check it, the courts. That is to say, the least democratic of all of them. Right? That in the end, the courts are the benefactors of this, not the president, certainly not Congress. All right. It doesn't have to be this way, right? For the better part of 175 years, it wasn't this way. If the founders' vision is to be realized, it shouldn't be this way. And that's my message to you on Constitution Day 2024. We've spent decades empowering the presidency and the courts at the expense of the most representative and democratic branch of our government, right? And it's time to reverse that trend. So thank you very much. If you like that, you can watch my newsletter, and I'll take questions. I got a little choked up at the end.
Well, thank you so much, Professor Vladeck. I love your messages, and I'm going to ask you a few questions, some that were pre-prepared and some that I came up with in response to your presentation. So one of the things that you talked about, you started with the actual text of the Constitution, which I think is great, and it's something, especially for the students who are interested in going into a legal education down the road, that's very important. One of the decisions we didn't talk about in today's presentation is Trump versus Anderson. So I'm wondering if you'll briefly just give an overview of that decision, and then my question about that decision is how can normal citizens, or how can lawyers, because we also have lawyers joining us from across the state, how can they tell which portions of the Constitution are self-effectuating and which portions need Congress to act before they can be, before they actually take effect?
Cool. Thank you. All right, so Trump versus Anderson is a case about Colorado, right? So we're in the neighborhood. And the basic question was whether any state by itself could disqualify from running for president a candidate on the ground that in the state's view, that person had violated Section 3 of the 14th Amendment. What is Section 3? So Section 3 of the 14th Amendment, a provision that was adopted after the Civil War, creates a categorical disqualification, an ineligibility to hold federal office, if two things are true. If at some prior point you had sworn an oath, right, like the one U.S. Attorney Hurwitz talked about, to the federal government, you were a federal officer in the civil service or in the military, one, and after having sworn that oath, you engage in insurrection. Not really hard to figure out why in 1868 Congress wrote this provision and the states adopted it, right? What is striking about the Trump v. Anderson ruling is the Supreme Court said states are not allowed to enforce that provision, that only Congress can enforce that provision. And that part of the holding actually got all 9 of the justices to agree, right? We're so used to hearing about the Supreme Court disagreeing and splitting along ideological lines. All 9 justices agreed it's up to Congress. They disagreed about how. So the 5 justices in the majority said Congress can only enforce this provision through a new statute, right? And the 4 justices who sort of concurred on narrower grounds said, well, we don't have to decide that. Let's save for another day how Congress might enforce it other than through a statute. Just to sort of spill the beans, how might they do that? Well, one way Congress enforces qualifications provisions is by refusing to seat people, right? If you're elected from a state and you're not eligible to be a representative or a senator, you have to be 25, right, to be in the House. Most of you are ineligible for that. If you nevertheless were elected in Idaho, Congress would not seat you, right? So could Congress refuse to certify a president's election if the Congress believed he was ineligible? And the majority says, no, it has to be a statute. So on one hand, right, that's a remarkable ruling that Congress has to implement this provision that certainly seemed to be, as you say, self-executing. On the other hand, I think it's actually, guys, deeply consistent with some of what I've been saying this afternoon, which is here's a constitutional provision that everyone agrees Congress could give life to, that Congress could provide a mechanism for enforcing, and Congress, just for various reasons, hasn't. And so, you know, I would not have gone as far as the majority did, but the relevant point is they left the door open for Congress. The problem is that this is a Congress that likes to walk past doors, right? We don't walk through doors, we walk past them. And here I think was another example of that.
Thank you very much. My second question is, you spoke briefly about a lack of legislation coming out of Congress. First, my question is, at what point, obviously you mentioned that there hasn't been any significant immigration reform out of Congress since I think you said 1986. I'm slightly younger than 1986, for the record. And when we look at how much technology and how much our society has changed in that time, I guess my first question would be, at what point does Congress sort of abdicating its authority become simply untenable? And my second question is, can you discuss any advantages or disadvantages of the current approach?
So, I mean, guys, most of this has happened in your lifetime. I mean, if you look at, there's some really cool visualizations online of where members of the U.S. House line up ideologically. And as recently as the 70s, right, you have plenty of liberal Republicans and you have plenty of conservative Democrats. So it's actually like, yeah, the blues on one side and the reds on the other, but there's a mess of, was it purple? Right in the middle, right? And over the 1980s, 90s, 2000s, you start to see sorting, where the middle just completely empties out. So that nowadays, right, it's been years since there was a Democrat in the House who was to the right of a Republican in the House. And that used to be actually quite common. Why is that happening? I think some of that's because of gerrymandering, right, polarization. What has that done, right? It's gotten us to here. Right, how does that sort of empower, like what does that produce? What it produces, guys, is it produces government by presidential and judicial crisis, right? Basically, all we're gonna have is flashpoints where presidents try to do things and the courts either allow them to or push back. And Congress is sort of on the sidelines, right? So what it means is more and more high-profile Supreme Court cases about federal policies, right? More of what we call nationwide injunctions, which have become a much more common controversial tool in recent years. Guys, more chaos, right? Because we're just not sure whether a new policy that we might like is actually going to be upheld by the courts or rejected, right? It really makes everything into a, can President X get policy Y through courts Z? And that's it. And I think, you know, there might be individual episodes in that story that we like, but overall, that's actually not a recipe for efficient, effective government. Keep in mind, the reason why we have a constitution, right? This is John Marshall in McCulloch versus Maryland says, you know, when it was deemed necessary to have a more effective form of government, we ditched the Articles of Confederation and wrote a constitution. As for, are there any saving graces to this system? It's a jobs program for lawyers. I mean that's it. Like now's a great time, right, to be a civil litigator, right, doing, you know, federal policy work because it's open season. Every federal policy, right, can be challenged almost anywhere in the country on almost any ground. And guys, that didn't used to be true. So, you know, it's great for law firms, and for those of you thinking about law school, it's a career. But you know, maybe I'm just being a little bit sort of narrow-minded here. I don't think there's anything healthy about it institutionally, right? Because, you know, even if we lived in a moment where we had a president I liked and courts I agreed with, and we don't, right? That would just be a sort of like short-term salve. It would not actually be sort of a healthy long-term solution. Guys, because even in that moment, right, half the country would think that the other half was illegitimate. Right? Even in a moment where I'm cool with what's going on, half the country is going to not be cool because they see a president they didn't vote for, or they see a Supreme Court controlled by nominees from the other party, right, doing stuff that they disagree with. And in a world in which all of that has legal as opposed to policy implications, right, we're going to continue down this road of divisiveness, not consensus building.
Excellent. So my follow-up question is actually relating to that same topic. So do you believe, or have you seen any data that would indicate that with more action from Congress, we would see less partisan legislation, or what would be the effects of legislation if we did have more action coming out of Congress?
So, right, some of this is just like design, right? So if you had, like, if Congress was doing, and guys, I'm not just saying more bills quantitatively, right? I mean like more substantive policy. So, right, anytime Congress creates a new post office, like that's a bill. You know, fine, but that's not, we're not talking about more post offices. Although I don't know, maybe in parts of Idaho we need more post offices. I think two things would happen with more legislation, right? The first is the more bills there are, right, the more need members of Congress have to work with each other. And the more need that there will be to forge, you know, cross-partisan coalitions on some topics, right? Hey, you know, join me on this bill and I'll join you on that bill. I mean, classic, old school, backroom horse trading, right? There's less of that these days because there are so few bills that actually pass. Right? Guys, in DC today, members of Congress, well, not publicly, but they'll privately tell you there are only 2 bills every year that have to pass, right? The budget, and the National Defense Authorization Act, and everything else is optional. In that space, there's much less room for compromise. So more compromise, which I think is healthy. I think it's good when we're agreeing with people on the other side about like what's, at least good compromise policy, but also more stable policy. Because the more that Congress is legislating, the less courts can block on the ground that Congress didn't authorize it. Right? Most of the time these days when courts block the executive branch, they're not saying that the executive branch violated the Constitution. They're saying the executive branch just didn't have authority under the relevant statute. The more Congress is providing authorities that are tailored to the moment, the less of that there will be. And the less we'll have like headlines about, Supreme Court thwarts Biden again, or vice versa.
Thank you very much. Our next question has to do with, your presentation focused on analyzing these things almost from an institutional power level, not focusing on partisan politics as much. What tips would you give, especially to the students who are here in the audience that are high school students, to understand these issues outside of the partisan sphere? How can they focus on institutional power? How can they focus on the history? What tips would you give them for that, as well as critical thinking?
Sure. An exercise I do with my students a lot is just change who the president is and ask the same question. Right? So, take a hypothetical, like I did this a lot with like post 9/11 arguments about the Bush administration, right? And I would say, well, imagine it was, Al Gore, or imagine it was Bill Clinton. Would you feel the same? Right? It's a rhetorical device, the mock trial, yay, rhetorical devices. But I think it's an important one, right? Is your objection to the notion that it's the office of the president exercising this power, or is your objection that it's this president? Because the more that it's this president, the more that it's not an objection about law, right? It's an objection about policy. And so I think it's often very helpful, especially when talking about presidential power, to put yourself on the other shoe. On the other shoe? Put the shoe on the other foot? Whatever, to finish the metaphor somehow. Right? And the thing about, like, would I feel the same way if I didn't like this president? Or if I did like this president? Like, would I still have concerns about this power? And I think that tells us a lot about how much our reactions are about the authority of the office of the president versus the actions of the incumbent. I think that's an important distinction that we don't spend nearly enough time on, right, when we talk about current events.
In light of your comments about Congress and its inability to work through highly partisan issues, one of the things that we've seen is more legislation at the state level, including voter-led initiatives. Can you talk about how those fit into some of your earlier comments? I understand that those aren't available at the federal level, but have we seen states basically fill the gap where Congress has failed to act?
So the short answer is yes and no, right? I think we're in, I think, a really exciting period when it comes to state democratic reforms. Every state is different. I don't have to tell you guys this. No, Idaho's just like Maryland, right? But what's really, I think, interesting is there are areas where states are increasingly asserting policy control, right, where Congress might have used to. So, reproductive rights is one example of this, right? We're seeing more and more states now that Dobbs has come along, creating state popular constitutionalism around reproductive rights. The reason why that is useful but not sufficient is because, guys, there are just some questions that states can't answer, right? Idaho is not going to have national immigration policy, right? Florida is not going to have national forest policy, right? And so, part of why the Constitution creates a federal system is to recognize that there are some issues that we want local and state governments responsible for, and that, guys, there are just some questions that they're not well situated to handle, right? National defense, hard to figure out which state we're going to put in charge. My vote is not, though, for Arkansas. Right? So, the reality is, yes, I think it's very healthy that there's been more push on the ground level in states with robust initiative processes to do that. I think that's great. It will only go so far. And it ought not to sort of excuse, right, the need for the folks we're sending to Washington to be responsible not just for what's in the interest of their parties.
Thank you. In your presentation, you spoke briefly about the Trump versus United States decision, the immunity decision, and you touched, I think, briefly on some of the potential long-term implications of that decision, but it was one that was highly publicized, discussed a lot in the media. Do you mind just kind of, again, just focusing on what the potential long-term effects of that decision are, and particularly whether there are any advantages or disadvantages that come out of that decision?
I mean, it's great to be the president. We talked a lot, guys, earlier in the presentation about the questions the Supreme Court has not answered. And sometimes it's actually healthy for the Supreme Court to have not answered a question because it means both sides can make plausible arguments about why they can do a particular thing. What's really important in the long term about the Trump immunity ruling is not what it says about former President Trump. And I don't even think it's what it says about criminal prosecutions. We have luckily not had a lot of criminal prosecutions of former presidents. I hope we won't have more going forward. Rather, right, it is one of the very few times in all of American history that the Supreme Court has sided with the president on a question of not just inherent power, but preclusive power, right? Power that Congress can't take away. And there's a long discussion in the middle of the opinion about the president's control of the Justice Department specifically that resolves questions that the Supreme Court had never resolved, right, about just how much control the president must have over his subordinates. So in the long term, I think the real issue is not the immunity part of the holding, but the Article 2 power part of the holding, which is going to tilt the scales, right, in these conflict scenarios more toward the executive branch. And it's going to put that much more pressure on Congress to try to push back. Congress isn't pushing back at all, right? And so if and when we have a Congress that pushes back, it's going to have a little more of an uphill climb thanks to that ruling.
So one of your specific areas of expertise is the intersection of national security law and executive power. Is there anything on the horizon that may be new in terms of that intersection that you'd like to share?
God, I hope not. The reality is that if you spend like 20 to 30 minutes reading about the sort of the deeper nuances of the president's national security powers, what you'll learn is that Congress, for better or for worse, over the years, has delegated an enormous amount of power to the president to act in lots of different emergencies, including things the president just calls an emergency. When President Trump built the border wall, or at least a small stretch of the border wall, the way he actually found the legal authority to do it was by declaring a national emergency, which allowed him to rely on a statute that let him repurpose military construction funds, quote, during a national emergency, unquote. Right? So even though Congress had not appropriated money, he got the money because he declared a national emergency. Guys, there are loopholes like that. There are sort of like, Rube Goldberg devices like that all over the national security statutory landscape. And, I have historically thought that many of those delegations are good, but that they all need sunsets. So a sunset, right, when Congress says a statute will expire, or at least a particular authority will expire after a certain period of time. Congress has put some sunsets on, but I think more sunsets would be the way to prevent abuses going forward. Because again, right, we're going to have presidents do things we don't like, right? The question is what's constraining them. And it's the constraints that I worry about more than the underlying powers.
In your presentation, you talked about Justice Robert Jackson. Justice Jackson dissented in a case known as Terminello v. Chicago. And he used this phrase that's always stuck with me, and I'm kind of going off script to ask you about this phrase, but he talked about how when the court, he dissented from that case, and I'm wondering if you can give the students some background on that case first. And he used this phrase where he said that if the court does not temper its doctrinaire logic with a little practical wisdom, that it will convert the Bill of Rights into a suicide pact. That's the phrase that he used. So I'm wondering, especially with Justice Jackson's background, if you can speak, this is a very broad question. I know I'm putting you on the spot in the last 5 minutes here, but I guess I'm wondering if you see any areas where you feel like Justice Jackson's concern is warranted in today's political landscape, in today's landscape with the courts, and just touch on that if you would, please.
So, I mean, I love the Constitution is not a suicide pact. The other most famous version of that argument, back to where I started, came from that guy. Right? So when Lincoln finally goes to Congress, when Congress is back in session in July of 1861, one of the questions is, why the hell did you suspend habeas corpus? Right? Because Lincoln, in April of 1861, had suspended habeas corpus, had one of our most important freedoms, the right to have judicial review if we're arrested. Right? Lincoln had suspended it unilaterally because he was worried about Maryland. And Lincoln, in his speech, gave an impassioned defense of what it would mean, right, if habeas corpus was used to undermine the country. Right? So he says, are all the laws but one to go unexecuted, and the country itself to go to pieces, lest that one be violated? Similar argument to the Suicide Pact. And his basic argument is like, guys, sometimes there are more important things than the Constitution. And that's kind of also, so Jackson was sort of being a little bit more picky. He was saying we should not interpret the First Amendment to put us in that position. But Lincoln, I think, made the better argument, which is there are times, and we hope they are rare, when presidents will actually need to violate the Constitution because they genuinely believe it's necessary to save the country. And if you guys think that sounds crazy, let me put it to you this way. Is it ever okay to drive through a red light? No. Someone said no. Okay, your sick parent is in the back of the car and you have to get them to the hospital, and it's a clear day and you can see for miles in every direction. Still saying no? No, right? When you get pulled over for doing that, are you going to say, well, officer, the red light statute has an exception for emergencies? Is that your argument? No. Your argument is, forgive me, you just don't give a shit about the law. Right? Getting your mom to the hospital is more important than paying a paying a ticket, right? And I think the problem is that we have a tendency to make everything about the law, right? And to try to rationalize everything in the law. One of Jackson's most famous opinions, his dissent in Korematsu, the Japanese internment case, he says something very similar. He says, listen, during wartime, the military is going to abuse our rights. You know why? Because it's wartime. And he says, that's unfortunate. We should be unhappy about that. He says, what we should not do is say it was legal, right? He said, we should distinguish. He says, it's much worse for us to say internment was legal than for the military to have done internment. And he was right, right? The point is that, not everything has to be legal to be right. Law and morality are different concepts. And so I think part of what we lose in so much of our contemporary discourse, we're so obsessed with wrapping all of our arguments up in law that we forget that actually law is not meant to do in all cases what is morally right under the circumstances, right? Law is meant to structure our institutions in a way that perseveres. And if that means every once in a while you have to violate it, fine. Lincoln, right, did not claim the power. He didn't say, I am unaccountable. He said, and if the people disagree, they'll vote me out. Right? So I think, to me, what is missing from our contemporary discourse is the idea that there's gradations of nuance when we talk about power, right? Should presidents be able to do X is not always a legal question, right? Sometimes it's a moral question. And so, to me, right, Jackson was saying something very similar, not just in Terminello, but in Korematsu. And I think not nearly enough of our contemporary judges and justices, at least outwardly, say the same things.
Thank you so much. And everyone, thank you so much for joining us for today's presentation. On behalf of Attorneys for Civic Education and the Idaho Law Foundation, as well as the University of Idaho College of Law, please join me in thanking Professor Vladeck for presenting today. And thank you very much for being a part of this. Having these nuanced discussions about the Constitution, about the history and the context are so important in today's society. And I'll just close with that and thank all of our partners again. Thank you so much.
Thank you.